Two questions about a large sum of money I lent a friend who suddenly died. The first question is, what's the procedure for claiming repayment from my friend's estate, which consists of his house? The second question is, how do I ensure that the executor pays my claim once the house has been sold and doesn't ignore the claim?
Tony, how much money did you lend your friend?
65,000.
And do you have something in writing proving it?
Yes.
Okay. Is it a formal loan agreement? Tony, are you there?
Yes.
Yep. Is it a formal loan agreement?
Yes.
So, and have you sent it to the executor and said he owes me £65,000?
Not yet, no, because the death has only just occurred.
When you say the debt has only just occurred, do you mean it must have occurred before your friend? Oh, the death. I'm sorry. What are the terms of the loan? Is it repayable on demand?
He started to repay it in instalments and defaulted. So there's a large lump sum still outstanding.
Okay. Did the loan agreement say that if he defaults, the whole sum becomes due?
No.
So does he actually owe the money now? Or, assuming he hadn't died, would he actually owe all the money now or just a few instalments?
Well, it all becomes due now, yes, now that he's died.
And the loan agreement says that, does it?
No.
Okay, because the fact he dies doesn't make the balance of the loan due sooner than it would have been. If he had 10 years to repay the loan, the estate will have 10 years to repay the loan. Although what would happen in reality is that they'd offer you a sum to buy it off early, so they could close down the estate.
The loan was to be repaid over 4 years.
Okay, so here's what to do. You need to find out who the executor is. Do you know who it is?
Well, I think I do.
Okay.
And I can find out in any case.
Okay,
I think I know who the executor is.
So you find out who the executor is. You send them a letter setting out your claim and including the evidence of the loan. And you ask for the £65,000, and you ask for your letter to be acknowledged. Make sure you get an acknowledgement. If it's not acknowledged, send a copy of it by email so that you have a record of it being sent with your letter attached, and also send a copy by recorded first-class post so that you've got lots of proof that letter was delivered. And the executor will send you a form that you have to fill in setting out the details of your claim. It's a standard form. It's relatively easy. Send that back. Again, make sure it's received. And then as things fall due, and it can take a year to wind up an estate, but as things fall due, you'll get the money. There's no reason to think that you wouldn't, is there, Tony? No, I was just being perhaps ultra cautious. Well, good. I'm glad you are, because that's the sensible thing to do. But I can't see there's any particular problem here, and the executor is the executor a solicitor? Is the executor a solicitor?
I don't believe so. I can't be certain.
Often there are
the person I think is going to be the executor is a relative of the deceased.
Often there are two executors. There's one who is a relative and one who is a lawyer.
Right.
And the lawyer does all the work, albeit charges the estate for it, but does the work so that it's all done correctly. If there's a solicitor who's one of the two executors, as I suspect is likely to be the case, then it should all go through very, very smoothly. But if you've notified the executor of your claim and they don't pay you, they are personally liable, Tony.